Hi, this is Josh Blackman. I am the president of the Harlan Institute, and it's my honor to welcome you to the 2018-2019 Harlan Institute ConSource Virtual Supreme Court competition. And today we're going to be arguing the case of Timms versus Indiana, and this is the third match. We are joined here by the Petitioners from Greenwich High School in Connecticut with Henry McGannon and Matthew Myers. And we are joined by the respondents from Lake Oswego, Oregon, with Lane Duckett and Lena Dial. The format today is petitioners get 15 minutes, respondents get 15 minutes, petitioners have 5 minutes for rebuttal, and respondents have 5 minutes for rebuttal. I turn over to my colleague, Julie Silverberg from ConSource. Julie, anything you'd like to add?
It's my usual, which is best of luck to the teams, and we are looking forward to hearing what you have to argue this afternoon. And for those of you in Oregon, I recognize it's still the morning for you, so the morning for you.
They were bright and early today.
Yeah.
Okay, wonderful. Okay, could the petitioners please unmute your microphones? Okay, and petitioners, you have 15 minutes to begin whenever you're ready.
May it please the court, I am Matthew Myers.
And I'm Henry McGannon, and we'll be representing Tyson Timms, the petitioner in the case of Timms v. State of Indiana.
Mr. Timms pled guilty to 1 count of felony dealing of under $1,000 worth of heroin. He was charged with a fine within the limit set by the state legislature of a maximum $10,000 fine. However, the state later sought the forfeiture of his Landover, which he had purchased for $42,000 earlier. Every court that has ruled on this case so far has either declared that this is an unconstitutionally excessive fine or did not rule on this matter because they felt that they were not bound to this constitutional principle.
In order to determine whether Timms is protected from the forfeiture of his Land Rover, 2 conditions must be met. The first is that the forfeiture of the Land Rover qualifies as an excessive fine, and the second is that the excessive fines clause applies to the states through the 14th Amendment.
The court was not presented with the first question since all lower courts found it to be true, since Austin v. United States allows in rem forfeitures to qualify as excessive fines, and this excessive fines fits the definition for excessive fines set in Bajikagian v. United States.
The question that must be answered next is whether or not the excessive fines clause applies to the states through the 14th Amendment. The first truly significant instance in which the Supreme Court ruled in favor of incorporating the Bill of Rights to the states was Gitlow v. New York in 1925. In this case, the Supreme Court found that the First Amendment guaranteed a freedom of speech extended to the state and local governments. This was a contrast to the decision reached in the slaughterhouse cases of 1870, in which the Supreme Court ruled against incorporating the Privileges or Immunities Clause of the 14th Amendment to the states.
But Counselor, let me just interrupt you. What was the right at issue in slaughterhouse? What was slaughterhouse about?
Well, interestingly enough, slaughterhouse is often looked at as an example of the 14th Amendment not applying the Bill of Rights to the states. And this is incorrect because the issue at hand was not actually in the Constitution. It was a state law regarding monopolies in Louisiana.
So what case did involve the Bill of Rights and the 14th Amendment from that time period?
Cruikshank v. United States is one example of such a case, and it took the use of slaughterhouses, limiting the power of the Privileges and Immunities Clause, and applied it to specific provisions of the Bill of Rights. Now, the excessive fines clause is not one of these provisions, which means that it would not violate stare decisis to incorporate this clause through the in Privileges or Immunities Clause of the 14th Amendment. However, it would have little practical impact whether or not it was incorporated through the Due Process or Privileges and Immunities Clause, but using the Privileges or Immunities Clause would have greater symbolic impact, as this is the original clause that was meant to incorporate the 14th Amendment Bill of Rights to the states through the 14th Amendment, according to the drafter of this amendment, John Bingham. The court has
Counsel, let me just talk about it for a minute. So we have slaughterhouse, which is 150 years old. We have Cruikshank, which is around the same age. Why should we go back and reconsider these really old cases?
Well, at the time that they were decided, it was perceived by some as judicial activism in favor of limiting the rights and impact of the Reconstruction Amendments, the 13th, 14th, and 15th Amendments to the United States Constitution. And constitutional scholars believe that the slaughterhouse cases and the cases following it have severely limited the rights of many marginalized groups of individuals. And according to Akil Reed-Amal, virtually no serious modern scholar of the Constitution, left, right, and center, thinks that the slaughterhouse is a plausible reading of the 14th Amendment. Therefore, if you go back and without actually overturning it, because it did not involve any specific constitutional principles, as Justice Hugo Black pointed out in his dissent on Adamson v. California, you would be able to symbolically not rectify, but make an impact, because throughout history, many principles of the bill would have been incorporated much more quickly had this Privileges or Immunities Clause been used.
Counselor, do you think that we should go back and reconsider our old substantive due process cases that relied on the 14th Amendment's due process clause?
No, we do not. We don't believe that incorporation through the Privileges or Immunities Clause or Due Process Clause has any practical impact on the outcome of this case. They both would involve applying this amendment to the states. And while some people have pointed out that if we use the Privileges or Immunities Clause, it would not apply to non-citizens, there's been no precedent on this. And actually, if you read the actual clause of the amendment, it's possible that if you interpreted the correct way, it would apply to non-citizens. This amendment states that no state shall make or enforce any law which shall abridge the privileges or immunities of the citizens of the United States. If you interpret the phrase, the privileges or immunities of citizens of the United States, as rights belonging to United States citizens, and the first half is saying no states can abridge those rights for anyone within the state, then the practical impact of the due process versus privileges or immunities clause is non-existent.
So, Counselor, let me ask you. So, you're saying that there's really no practical difference, right, between using privileges or immunities or using substantive due process. So, why should we disturb the apple cart, so to speak, if there's actually going to be no substantive difference in terms of how we determine whether or not something applies to the states?
So in this case, it does. We're arguing that it doesn't really matter whether or not it's the 14th Amendment clause to due process or the excessive or the privileges or immunities clause, because as we know in this case, the due process clause is all about the process that's guaranteed. And in the case, Tyson Timbs, the petitioner, he isn't actually arguing that the state of Indiana did not give him a process. He's just arguing that the punishment was unjust and did not fit the crime.
Yeah. So therefore, this, if incorporated through the due process clause, it would be an example of substantive due process, which is a claim supported by the case BMW of North America Incorporated v. Gore from 1996. This is implying that this principle has a deeply rooted in our nation's history and fundamental to the scheme of our ordered liberty, and remains essential to the idea of liberty to this day.
So, Counselor, I just want to make sure I'm clear on your answer. So your answer is you could do either. You're not going to argue for one route over the other.
What we're trying to argue is that Tyson Timbs is protected. We're representing Tyson Timbs, the petitioner in this case, and if it's incorporated with the due process clause or the privileges or immunities clause, he's protected from the forfeiture of his Land Rover.
Right,
How,
but given the choice between the two,
um,
do you have a position on one over the other?
the Privileges or Immunities Clause has a greater symbolic impact. For the last almost 150 years, the Supreme Court has had to use the Due Process Clause, whose original purpose was not to incorporate the 14th Amendment to the states, as a method of applying these rights to the state.
So you just said that. So what evidence do you have to support that assertion?
John Bingham, who is the author of the 14th Amendment, stated that the original purpose of the Privileges or Immunities Clause, I don't have the exact quote, but he said the original purpose of the Privileges or Immunities Clause was to make the states follow the Bill of Rights as well as the federal government. And had this interpretation been done, the black codes of the Reconstruction era would have had significantly less impact, particularly in the instance of excessive fines, which was one of the primary methods of oppression. And without excessive fines, the system of vagrancy and debt peonage, which has been referred to as slavery by another name, would not have been possible. And had the Privileges or Immunities Clause been interpreted in its original meaning, that would not have been possible, according to the Supreme Court.
Okay. Continue.
There's a lot of other.
So, the Gitlow v. New York case was a contrast to the decision reached in the slaughterhouse cases. And Gitlow v. New York overturned the precedent of not applying the Bill of Rights to the states, beginning the process known today as incorporation. And so the Supreme Court has on several occasions set forth guiding principles for how a right can be incorporated. The first, established in Paco v. Connecticut, states that rights, quote, of the very essence of a scheme of ordered liberty are applied to the states through the Due Process Clause of the 14th Amendment. This is certainly true of the Excessive Fines Clause, as it has been embodied throughout history through the principle of salvo contenimento. This principle states that no fine should leave the perpetrator financially ruined. And this principle has existed since the advent of the freedom from excessive fines in the Magna Carta, upon which the English Bill of Rights is based. And the English Bill of Rights, this key idea was restated in the Virginia Declaration of Rights that James Madison used as the basis for the Eighth Amendment. The presence of the fundamental principle of salvo contenimento is supported by the decision in Spalding v. New York, which declared a fine excessive, as it would be impossible for the fine to be paid given the financial status of the accused.
My colleague mentioned the history of the freedom from excessive fines going all the way back to the Magna Carta and the English Bill of Rights. And this is primarily due to a history of abuse by the British government. It was used as a means of collecting revenue after the Magna Carta was passed, and the Tudor kings, Charles I, Charles II, and James II, were all the most egregious in their violations. In fact, they used excessive fines as a means of collecting revenue. And this is, without a question, a violation of our principle of innocent until proven guilty, because these kings had an incentive to find people guilty even when they were not guilty. And this
so, Counselor, if I can interrupt you for a minute. If we go ahead and we overrule Slaughterhouse and we overrule Cruikshank, how are judges supposed to know exactly what is a privilege or immunity? Maybe the excessive fines clause is an easy case, but there's a lot of different directions a court can go in. What frameworks we use to decide what a privilege or immunity is?
A privilege or immunity from the original 14th Amendment was any positive right, a privilege, or negative right, immunity that people possessed because they were citizens of the federal government of the United States. The most notable is the first 8 amendments of the Bill of Rights. Those were all negative rights, immunities. But since then, a lot of privileges have been declared by the Supreme Court. For example, the privilege of equal marriage opportunity established in Obergefell v. Hodges. Now, this is a privilege, but
that was a due process case. It wasn't a privilege or immunities case.
Yeah, so it was a due process case, but the due process has given people a privilege. And even though these are separate clauses, they operate under the same principle of giving people who did not have certain privileges or immunities.
And Counselor, you have 1 minute left.
Okay.
Just so you know, so you can start wrapping up.
In your last minute, I'm sorry to take up some of your time, but I'm just having some difficulty with the argument that there's no difference between the two. So is the argument that the court has read the substantive due process clause to function in a way that you think the privileges or immunities clause was originally intended to function, and that we should be more faithful to the text by interpreting things via the privileges or immunities clause? I'm just trying to understand what your argument is on that point.
Yes, the due process clause has, on a case-by-case basis, selective incorporation. It was selective, applied certain rights of the Bill of Rights, which was intended. The privileges or immunities clause was originally intended to apply all of the rights at once, and it would have been a much quicker process.
Okay, Counselor, you're out of time.
Okay, thank you, Your Honor.
Okay, very good, thank you. Okay, petitioners, please put yourselves on mute. And respondents, please take yourselves off mute.
Hi, can you hear me?
Yeah, I can hear just fine.
Great.
Okay, and you have 15 minutes. You can proceed whenever you're ready.
Okay. May it please the court that I, Lena Dial, and my colleague Wayne Duckett, for the respondent in the case Timms v. State of Indiana. In summation, we will be proving the effectivity of the due process clause and the impotence of the privileges or immunities clause. More specifically and firstly, we'd like to discuss the practical advantages of the due process clause. Firstly, the language of the due process clause is far more inclusive than that of the privileges or immunities clause. Having the prohibition of excessive fines and bail apply to, quote, any person rather than, quote, citizens would be in line with the general sentiment of the purpose of the due process clause. In fact, during the First Continental Congress, it was John Dickinson's intention to enumerate the privileges or immunities clause in the Articles of Confederation to, quote, the free inhabitants of each of these states, paupers, vagabonds, and fugitives from justice excepted, shall be entitled to all privileges and immunities of free citizens in the several states. Though this intention was lost in the drafting of both the Articles and the Constitution, the standing privileges or immunities clause became tailored to citizens and lost its intent entirely. Every person under U.S. jurisdiction should have the right to be protected from excessive fines, non-citizens being some of the most vulnerable populations in the country. The prosecution will have you, the petitioners will have you believe that there is no precedent for non-citizens being outside the protection of law. But if we look at the case Dred Scott v. Sanford, there's a prime example of the consequences for having non-citizens be outside the protection of the law. Dred Scott ruled that, regardless of servitude status, African Americans could not be citizens, and as such, the population had no capability to sue or vote, and no possible way to remedy this under the system, leaving only violent or radical action as the option left to them to create change. Even though the ruling was deemed invalid after the 14th Amendment was passed, it demonstrated the terrifying possibility of non-citizens being outside the protection of the law. Therefore, rights incorporated under the Due Process Clause will never run into this issue, regardless of what may happen in the future, political whims, or swings on the Supreme Court. The language all persons is crucial to the effectuality of the intent behind incorporating rights. Secondly, because the Due Process Clause is procedural at its heart, the use of these cases in future arguments would give the incorporated excessive fines clause a much greater chance of holding at the state level. The incorporation doctrine is just one example of this, applying one reasoning to the first 10 amendments. Justice Clarence Thomas stated that, quote, the 14th Amendment's Due Process Clause is not a secret repository of substantive rights, substantive guarantees against unfairness, end quote. However, the clause is a procedural protection and therefore more likely to hold at the state level. Additionally, this inclusivity would not allow federal overreach, further protecting anyone under U.S. jurisdiction by granting access to rights incorporated from the Bill of Rights.
Counselor, I want to ask you a question. So the way that you're reading the substantive due process clause is fairly narrow. Is that consistent with our previous substantive due process case law?
I would agree. I would say it is. If you look to Gitlow v. New York and Chicago v. McDonald, both of them incorporate rights using procedural rather than substantive language, so that way the lake of whether the law has been violated or not is unmuddied by circumstance.
So what were the rights at issue in Gitlow and McDonald?
Gitlow v. New York incorporated the First Amendment, the right to free speech, right to expression, all that good stuff. And then Chicago v. McDonald was actually recently in 2002 the right to bear arms.
And how would you describe those rights as procedural?
Because there's not necessarily a statement in that. There's not necessarily language in the actual majority opinions of the court cases that states that citizens can or cannot do this. It's more instead what governments can or cannot limit. And also the multitudes of case law that have occurred since then, especially with free speech, have all been focusing on the procedural aspects of
so then under your reading of procedural, what wouldn't be procedural, right? That's a pretty broad, so you're sort of on one hand trying to narrow the substantive due process clause, but on the other hand, you're trying to broaden the definition of procedural.
I guess, not to contradict myself, but I guess when incorporating the First Amendment in Gitlow v. New York, it definitely was incorporating the right to free speech, which is something that citizens hold. But the interpretation and the actual like hard law surrounding that for like Brandenburg v. Ohio, Schenck v. U.S., all of these things have been procedural rights of what the government can and cannot limit. So the real interpretation that really exists within the context of our current political system has been about the procedural rather than substantive rights. And so we'd like to see the same thing happen for the excessive fines clause.
Can you give me an example of a right that would not be procedural under your definition?
Yeah, sure. How about the right to attorney in the Fifth Amendment? That's definitely a substantive right.
That's a substantive right different from from free speech.
Yes. No, sorry. The right to free speech in and of itself in the First Amendment is a substantive right, but the practical law that surrounds it is all procedural.
And why isn't the practical law of ensuring that a person has a right to legal counsel, how is that not procedural?
I'm sorry, you cut out. Could you repeat your question?
Yeah, so you said the right to legal counsel is not procedural. How is that not procedural?
It's a hard right. It's something given by the government to the people rather than something that the text of the document or the text of the law limits the government from doing.
Okay, I'm going to move on from this, but I think there's some things that I'm confused about in terms of how you're using the language to justify both a narrower and yet at the same time broader interpretation of substantive due process. But I'm going to let you continue.
Okay, thank you. Okay. So thirdly, we'd like to argue that the privileges and immunities clause is impotent after the slaughterhouse cases. And I won't dwell on this very long because it's sort of repetitive, and I think everyone present is familiar with the slaughterhouse cases. But we'd also like to look back to the Articles of Confederation once again. Historically, the Articles of Confederation enumerated the privileges or immunities as a right that gave citizens among the United States the same rights among all the states, therefore preventing interstate discrimination. In fact, Madison wrote federal.
Oh, so can I interrupt you just for a minute? I'm sorry. We've been talking about slaughterhouse a bit. Let's talk about Cruikshank for a bit, right? We wouldn't have to overrule slaughterhouse to give the petitioners what they want. We could just overrule Cruikshank. So how do we handle that issue, right? Why? Let's talk about Cruikshank for a bit. Was that case correctly decided?
I would argue that Cruikshank was correctly decided. I'm sorry, okay. I'm not familiar with Cruikshank.
Okay. Okay, that's fair. I appreciate the honesty. Okay, proceed with your argument.
Yeah. Okay. So Madison's Federalist 42 stated, quote, "Those who come under the denomination of the inhabitants of the state, although not citizens of such state, are entitled in every other state to all the privileges of free citizens of the latter, that is, to greater privileges than they may be entitled to their own state." Once again, Madison's Federalist 42 demonstrates the complete loss of meaning that occurred over the course of the privileges or immunities clause's lifespan. The original intent has been entirely obliterated by both the writing and interpretation of the Constitution. Furthermore, although historically the definitions of the Article 4, Section 2 privileges and immunities clause and the 14th Amendment privileges or immunity clauses have been in line with Madison thinking, if the excessive fine clause is incorporated under this umbrella, it will subsequently change both definitions in the legal realm. The definition is specific, the current definition is specific to interstate discrimination, as the clause's origin is in the Articles of Confederation, when people were not guaranteed the rights to own property or operate businesses if they were not a citizen of that state. The importance is evident when examining potential legal and political consequences. If the definition changes, years upon years of legal precedent and protection are essentially null. Unfortunately, this clause is bounded too much history and too narrow of a definition to be applicable today. To attempt to do so would be a radical diversion from its intended purpose and a blemish on the record of modern interpretation of law. Additionally, the Due Process Clause holds favor in terms of precedent or stare decisis. Creating an incredibly strong legal foundation to rest on, stare decisis has given the due process a great advantage over the Privileges or Immunity Clause, and the Privileges or Immunity Clause simply falters in this area of law. For example, many rights that citizens consider essentially sacred were once unincorporated and little heard of, unless you happen to be a scholar of the Bill of Rights. The holding in Chicago, McDonald v. Chicago, incorporated the Second Amendment right to keep and bear arms through the Due Process Clause. Gitlow v. New York also used the Due Process Clause to rule in 1925 that the First Amendment right to free speech was legally protected. And politically, America would be in an extremely different place if not for the incorporation of rights such as these, once unheard of by the general public, although incorporated through the Due Process Clause. With the history and precedent that these landmark cases provide, the Due Process Clause has a considerably more trustworthy foundation. Allowing excessive fines to follow in the footsteps of rights such as these would lead to a more protected form of higher law. The excessive fine clause truly reaches its constitutional power in that it cannot be overruled by the states and takes first priority in terms of protection. Until this clause—
Hey, Counselor, can I maybe take a different trajectory? Let's assume you're right that we should use the Due Process Clause to incorporate the excessive fines clause. How should we resolve the case of Tyson's Tim's, Indiana? How would that case turn out in your mind?
We would incorporate the excessive fines clause through due process.
Right. So my colleague on the bench here is saying, let's assume that's right. We're going to incorporate the excessive fines clause. In this case, was there an excessive fine?
Yes, there was.
Okay, take us through that analysis.
Like opposing counsel said, there are two rules to determining an excessive fine. Measuring the fine against the weight of the crime, and Tim's is most money he had to pay for fine was, I believe, $1,000. So it would violate that. And then the second step to determining an excessive fine is,
I believe it's determining that the excessive fines clause applies in that situation, which we would we would do through due process.
Okay, so if you were to distill this down to, you said there's two parts to determining this. So don't give me anything about the facts of this specific case. Just give me, this is step one, this is step two. You get this answer at step one, you get this answer of step two, you either do or do not have an excessive fine. Take me through that.
Okay, so I believe that the standard that should be used for excessive fines is one, measuring the fine that's being imposed against the highest fine that they had to pay. In this case, I know you're going to talk about specific in this case, but the fine would be egregious, and so then the next step would be the salvo contenimento concept of does this fine put this person into financial ruin? And using those two steps, we would determine, is this an excessive fine?
Okay, and what was the crime at issue again in this particular case?
There was Tim's was trafficking drugs across the border.
Okay, and was he using the vehicle in question to traffic these materials across the border?
Yeah.
Okay, and so it should be relevant to us whether or not somebody's using an expensive car or an inexpensive car. So would it be excessive if it was a Toyota Corolla instead of the car that he had, which is more expensive?
Well, it all depends on the value of the fine that the court found in his settlement, which was $1,000, which was his highest fine. And I mean, comparing the prices of trucks, I don't think that it's important to really compare the truck's values. I think it's important to compare the price of the vehicle to the price of the fine that he had to pay.
I agree. I'd like to just add on to that and say that to compare the
Counselor, you've got 1 minute left. Counselor, sorry to interrupt you. You've got 1 minute left. You want to wrap up your arguments, please?
I was just going to say to compare the state of the truck versus a Corolla is sort of opening up the door towards legal discrimination and sort of treating people differently based on their financial status. When the reality of the law is that it should treat everyone equally, regardless of whether they have an expensive truck or not. The fines should be the same.
Okay, you have about 15 seconds. You can waive if you like.
That's okay. I'll just say in conclusion, the only effective way to incorporate the excessive fines clause is through the due process clause. And I hope we prove that enough for your honor.
Okay, and that's time. Thank you. All right, 5 minutes for the petitioners. You can begin whenever you're ready. Please respond and put yourself on mute. And if the petitioners can take yourself off mute, and you have 5 minutes whenever you're ready.
Thank you. One of the first points I'd like to refute that the respondents made is that the idea that rights are granted by the government. This goes extremely in contrast to the history and the foundation of the United States. So in the Declaration of Independence, it said, quote, "We hold these truths to be self-evident, that all men are created equal, that they are endowed by their creator with certain unalienable rights." In there, it does not say that the government provides the people with rights, because that is only the job of the creator, and it is the job of the government to ensure that these are protected.
In addition, the respondent claimed that the fine of the Land Rover was not excessive, and they said that there were two principles that there should be weighed. They should measure the weight of the fine against what the legislature states. The $42,000 worth of the Land Rover was grossly over the $10,000 maximum. They also said that it should not leave the perpetrator destitute, which it did because the Land Rover was purchased with life insurance money from his father, and he did not have much else after that. Third, we would like to address the distinction between procedural due process and substantive due process. The respondent claimed that this is a procedural due process rather than substantive. However, BMW v. Gore, in the decision, it actually stated that the protection against excessive fines would be an example of substantive due process. This is because procedural due process refers to protections during that process of a trial. Substantive due process refers to protections of rights not specifically during the process of a trial, but deciding whether somebody can, not specifically during the process of the trial, but are still related to the idea of due process. This is substantive because the fine is only imposed once the trial has been completed, and the idea of liberty and rights of the accused is still in question.
Next, another claim that the respondent said is that the Privileges or Immunities Clause only protects federal citizens. And while the Privileges or Immunities Clause only protects federal citizens, the act of imposing an excessive fine on Mr. Timms, a U.S. citizen, is a gross violation of this constitutionally enshrined protection. And thus, the Privileges or Immunities Clause certainly applies in this case, and it ought to be the vehicle for the excessive fines clause's incorporation.
In addition, there has been no decision and there's no precedent on whether or not the Privileges or Immunities Clause actually applies to citizens, which means that multiple interpretations of the text of the amendment are in order. If it is interpreted as the privileges and immunities of the citizens of the United States as one phrase as a whole, saying these are the privileges that that are granted to citizens of the United States. No state can infringe upon them for anybody that are inside the jurisdiction of that state. Finally, we would like to refute the idea that the Due Process Clause is a more inclusive measure. Actually, the original intent of the Privileges or Immunities Clause, as defined by its principal author, John Bingham, was to apply all the rights of the Bill of Rights immediately to the states, making it an at least equally efficient method of applying the Bill of Rights to the states. Therefore, it is not a more, it's in fact, the Privileges or Immunities Clauses is in fact more inclusive, as it would have been able to protect these rights in a much quicker manner, making many of the violations of civil rights throughout the late 19th and early 20th centuries impossible, most notably the Black Codes during Reconstruction era. In addition, the respondent brought up the Privileges and Immunities Clause.
1 minute left, Counselor.
The respondent brought up the Privileges and Immunities Clause, which is a different constitutional privilege with similar language, and the interpretations of these two clauses should not be confused with each other, because the original intent of them was different. They were written 100 years apart. Therefore, they should not be confused. In conclusion, the idea of using the Privileges or Immunities Clause does not undercut the precedent of due process. It adds to the protections of rights of citizens of states from those states which can be oppressive but can also reinforce their rights. It adds more and furthers the original goal of equality as stated from the 14th Amendment. It will show regret over the treatment of the marginalized groups that have suffered under the—
Okay, and that's time.
I was just going to say one more.
Okay. Okay, very good. All right, if the petitioners put yourselves on mute, please. And the respondents, please take yourself off mute. And you have 5 minutes. You can begin whenever you're ready.
All right. First of all, I would like to clarify for the petitioner and Your Honor that the respondent's official position is that the fine in this case was excessive. I don't know if it cut out, but we did state that the fine was excessive. It violated both the state legislature agreement that the maximum fine would be $10,000. And the respondent does respect that and agree that that fine was egregious and excessive. I would also, the petitioner claims that the intent of the Privileges or Immunities Clause matters in this case, and I believe that it is irrelevant because the interpretation to this point in time has completely obliterated the original intent. In our brief, we stated that both Madison, John Dickinson, and the Continental Congress believed that the Privileges or Immunities Clause should be more inclusive, but unfortunately the interpretation of this has not reflected that. And so I believe that the Due Process Clause would be more inclusive because of this interpretation over time. And secondly, the petitioner claimed that the Privileges and Immunities and the Privileges or Immunities Clauses are different, but in Slaughterhouse, they were defined as the same. And so if we change the definition of one, we have to change the definition of both according to Slaughterhouse. And so maybe it was misinterpreted as we mistook them, but it is important that we realize that if we change one definition, we have to change the other according to the standards set in Slaughterhouse. As for the petitioner's first argument, they claimed that the incorporating it under the Privileges or Immunities Clause would not violate stare decisis. It would because of Slaughterhouse. And they also claimed that people don't take Slaughterhouse seriously, and that's not the case. The primary reason why privileges or immunities hasn't been incorporated and hasn't been used to incorporate other rights is because of slaughterhouse, and because people feel that violating stare decisis would be essentially useless when the due process is more inclusive and has a stronger legal foundation. And I would also like to refute the petitioner's claim of symbolic impact. While I agree and respect that symbolic impact is important, I think that practical application is more important in this case, because while I know that the Privileges or Immunities Clause has a lot of symbolic meaning in the 14th Amendment, the Due Process Clause would be far more protective of citizens and people outside of the citizen label. And we see that in Dred Scott, when we see that people who aren't considered citizens are outside the law. And I believe that excessive fines is something that minorities and people outside of the citizen label should never be separate from. And thirdly, I'd like to refute the petitioner's point that that since Tyson Timbs is a citizen of the United States, that we should incorporate under privileges or immunities. We are setting a standard here for as long as we interpret the Constitution, and I believe that we should be thinking in more of a larger picture.
1 minute, you have 1 minute left, Counselor.
All right. We should be interpreting this in the larger picture rather than the narrow scope of this case and this person. Just because this person is a citizen of the United States does not mean that every person who ever comes under the umbrella of excessive fines will always be a citizen. The petitioner claims that there has been no precedent proven on the Privileges or Immunities Clause, whether or not it is inclusive or not. And that is because no one has interpreted the Privileges or Immunities Clause since the slaughterhouse in Crookshank, because it's legally impotent, it's dead. There is a difference between due process and privileges or immunities because of the word citizens. Due process is inherently more inclusive, and I think that the petitioners claim that these would...
Okay, can you finish your sentence, Counselor?
...do the exact same thing is ignorant to the actual statement of the word citizen.
Very good. So is it dead or mostly dead? Okay, probably won't get that reference. There you go. Okay, thank you so much. That will bring to a close match number 3 for the virtual Supreme Court competition. I'd like to thank both teams. All 4 of you did a wonderful job. You make us very, very proud on an annual basis how you continue to raise level performance. You did a great job. These are hard topics, and I think you would do better than a lot of law students who have the same exact tournament. So thank you so much. Julie?
Yeah, just want to reiterate what Josh said. You should be very proud of how you performed today. As you know, you had to write a brief, you had to do a first round, and then you're here in the second round. So you should be very, very proud of the work product that you've created for this and for your performance during oral argument today. We've been doing this for 6 years now.
I think 7. Oh,
7 years. Oh my gosh. So every year the students get stronger and stronger, and that's certainly true this year. So we congratulate both teams for a job well done. We expect to have information about the 2 teams that will be competing in the championship round in Washington by probably early next week.
Okay. And with that, I will draw to a close this session. Court is adjourned. Thank you both so much.
Yeah, take care.